accordingly this certificate is dismissed as well. Sign correct.
Okay. It's signed.
From date is item 25, second April 118 of 2022.
I am the original plaintiff. My suit was dismissed by the trial court, affirmed by the first. I filed a suit against the state for declaration of my right title interest, and that has been dismissed. And for confirmation, primarily on the ground that there was a notification by the state under section 29 of the Indian Forest Act, whereby it is said, relying on that notification, my suit has been dismissed. One of the primary grounds, I will not say that was the sole reason, but one of the main grounds. Another is, Your Lordship, another is that although I have stated in my claim that I had served notices under section 80, that I have failed to prove. I had produced, registered these postal receipts and all, but I had failed to produce the registered letter. That is one. But Your Lordship, only one. Yes, only one. Now, because this question with regard to section 29 of Indian Forest Act, it regularly falls for consideration.
Academically decided. If otherwise the section 80 application is mandatory and you are not approved, then under such circumstances, academic discussion may be. In an appropriate case, we know that there are so many cases on section 29 of the Forest Act. अभी तक कोई decide नहीं हुआ है.
वैसा नहीं हो रहा, जो होना चाहिए वो नहीं.
होना चाहिए मतलब आप बहस भी करेंगे तो कहाँ से होगा?
वो नहीं है.
Because on the face of it, when your section
But Your Lordship, I had produced the postal receipts.
that's not sufficient.
I had made statement.
किसको क्या चिट्ठी लिखा है, that is who will decide that. You should have produced it. That is absolutely necessary. What is the nature of letter you have written? To whom you have written? Section.
And another ground was that I had failed to prove the link from the original purchaser to me. That I have failed. This is all.
So, your otherwise also you technically could not establish.
No, the courts below could not have gone into that question. If it would have been a suit between me and my vendor, then the matter would have been different. I say that a particular person who was the ex-landlord, he had settled the land, and the person to whom he had settled, he by registered deed of the year 1950, he transferred the land to a third party. And that third party, to whom by registered deed of 1950 the property was transferred, he by way of oral sale he had transferred me. This is my, yes. But thereafter, in 1964, there was a suit by the same person who was a vendee in 1950. He filed a suit against me, and then that there was a compromise, and that based on compromise that his suit was dismissed. So this
that
question.
Compromise will not be binding on any other person.
No, it would not be. But this, whether it should transferred from my vendor to me, this could not have been gone into by this in a litigation between me and the state. This is my example.
Dismiss तो करना अपना है. ऐसे नहीं कर सकते. Academically कोई issue तो.
Academic नहीं, but Your Lordship, it was This is one of the ground that he has. Only section 80 is problem. Otherwise, the courts below both have relied on section 29 notification and have dismissed my suit only on that one without going into other questions. And second,
Only on section 80.
yes, 29 of Indian Forest Act. And second judgment which they have relied upon is Your Lordship, a landmark judgment of Honorable Supreme Court, where under Bihar, not Bihar, Forest Act of 1980, Forest Conservation Act Section 2 was interpreted by Honorable Supreme Court in one of the landmark cases, T.N. Godavaran case. So, relying on that, the court below both have dismissed my suit and the appeal also. But both these questions are absolutely not in law. Absolutely on law, the courts below have merely by issuance of notification under section 29, the land does not stand transferred from the of any private person to the state. Because section 29 itself says that it contemplates a situation where it says that the notification is being issued, but this finding Your Lordship would get from internal page 20 of the trial court judgment, and Your Lordship is reading trial court or
I'm right.
section page 20 internal para 17. Or I can read it before that also. Actual finding starts from page 17. Page 17, para 15. But relevant portion which I was showing was page 20.
You see, come to para number 18.
Para 18.
Yes, the page
Yes.
is page 2. Step.
First, if Your Lordship would allow me to place para 17 and then 18. Contrary to the case of the plaintiff, defendant number 1 improved exhibit A series and B, which shows that the suit land has been notified as protected forest, and the plaintiff save and accept oral evidences showing the nature of the land as Gair Majarua Khas, failed to bring any concrete, reliable documentary evidence which may disprove exhibit A series and be proved by defendant number 1. Exhibit A is by section 29 notification. And then, para 18 it says, since the plaintiffs have failed to prove the factum of their acquiring title over the suit land from Rangu Ram by virtue of oral transfer, as such, the further case of the plaintiff regarding transfer of suit land by registered deed of sale exhibit 4 to Rangu Ram and so, Musabi Singh and so, who in turn got settlement from ex-landlord becomes innocent.
Like this. Like this?
This finding I can show that this is absolutely erroneous. Your Lordship may kindly see
Oral
oral transfer from, because the first transfer was by way of registered deed. First transfer was by way of registered deed. Now I say that
You claim the property by way of oral transfer.
but
That
Your
we
Lordship,
cannot recognize.
but it would only be a matter between me and my vendor.
Maybe.
My vendor had acquired
you are
title by
fighting
way of.
against the state, right? You have to prove your title properly.
But Your Lordship,
See, anybody cannot come and your vendor. Did you make your vendor party in the proceedings?
my vendor,
Did you make it party?
there was already a suit between me and my vendor.
No, that ended in a compromise. Why didn't you make him a party in the suit?
After Your Lordship, the first suit it has been dismissed by way of a compromise. Then whether subsequent thereto I'll again make the same person as a party.
That compromise to registered in the registry office?
No.
Then what is the value of that compromise?
But Your Lordship,
You are
they
aware that is
ultimately,
required to be registered, compulsorily registered, isn't it?
but Your Lordship, they withdrew the suit
Maybe.
ultimately
Whatever
by
it
way of
is.
compromise.
You see, withdrawal of suit by way of compromise is different from disposal of suit by way of compromise. Disposal of suit by way of compromise.
It was ultimately.
It results in a decree declaring the title of one or the other person. But if you enter into a compromise outside the court and then withdraw the suit, that will not happen. Where is the decree? Does the decree confer any title on you?
No, it only says that plaintiff suit is dismissed.
Is
That was the
dismissed?
term of compromise.
That's it.
So,
That cannot be a term of compromise.
Yeah,
The term of compromise would be that I acknowledge the title of the defendant, and then the party, there is a difference between the two. You are aware of the
Your
technicalities
Lordship,
of
they
law.
had filed a suit against me and
No,
they ultimately on the based on compromise.
No.
So therefore I say,
You see, based on compromise, they withdrew the suit. You should have insisted that based on compromise, let there be a compromise decree declaring my title. And then the compromise would have formed a part of the decree. This did not happen.
but Your Lordship,
And that particular decree, in order to actually give you title, was compulsorily registrable.
but Your Lordship, all
The
these
decrees are also
questions,
registered.
all these questions could have arising on
आपको पता
two
है, क्यों
grounds.
आ-
First, that
No.
the person to whom the original property suit, it was already registered in 92. Now it is a question whether he is disputing my title or not. He did not dispute my
He
vendor
did not.
because he filed a suit and withdrew. Then what would be the
अभी
consequence?
तक section 29.
Whether the state could have taken this ground.
Yes. They could have.
State could have
You
said.
have to make out your own case. You have to prove your own title. You forget about the state. Where is your case?
My case is.
सेक्शन 29 जैसा इशू हम ऐसे केस में डिसाइड करते हैं जिसका टाइटल ही नहीं है प्रॉपर, नहीं करना।
लेकिन ये क्वेश्चन दिस वाज बिटवीन मी एंड द थर्ड पार्टी who filed the suit withdraws, so therefore they could have raised this question, not a third party. The state could have only taken a plea that this judgment was not binding. That is all.
Second appeal number 118 of 2022 for the Learning Council appealing on behalf of the applicant. This appeal has been filed by the plaintiffs against the judgment dated 31/5/2022, which is acted decree signed on 6/6/2022, passed by the District Judge Roman Court Zaliban in civil appeal, which is acted title number 71 of 2019. Thereby, the appellate court has dismissed the appeal and affirmed the judgment dated 11 September 2019, decree signed on 24/9/2019, passed by the civil judge within bracket senior division -1 Zaliban in title suit number 131 of 2007. The Learned Council has submitted that though the plaintiff has lost in both the courts, but still a substantial question of law arises for consideration. He submits that the transfer of the suit property, the plaintiff had filed the suit seeking a declaration and confirmation of the title and possession over the suit land, and also permanent injunction against the number 1 and 2, and also and also in alternative for recovery of possession if the plaintiff is found dispossessed from the suit land. The Learned Council has submitted that the plaintiff was claiming the suit property through chain of registered deeds, but the immediate vendor of the plaintiff did not execute any registered deed, and there was an oral transfer. He submits that that there was a suit between the vendor of the plaintiff and the plaintiff,
Yes.
which was title suit number 28 of 1964, but it ended in a compromise and the suit was dismissed as withdrawn, and consequently the vendor of the plaintiff was not in a position to dispute the title of the plaintiff. The learned counsel has submitted that the said compromise has not been properly considered by both the courts, and on technical grounds the suit has been dismissed. He has also submitted that the suit has also been dismissed on account of not proving the notice under section 80 of CPC. He submits that the postal receipt was produced before the court, but the notice was not produced, due to which the finding has been recorded against the plaintiff. The learned counsel submits that production of the registry notice was more than sufficient to prove the service of notice under section 80, and therefore this aspect of the matter has also not been properly considered by the courts. The learned counsel further submits that the defendants had relied upon notification issued under section 29 of the Indian Forest Act, and the provision of law and its applicability to the suit property was also not properly considered. And therefore, the appeal be admitted for finding. After hearing the learned counsel for the appellant, this court finds that the learned trial court framed as many as 10 issues for consideration, which are as under. This court finds that the dependent state, all are state,
Yes, rest are proof of law. Main contesting is.
the contesting dependent state by written statement that no notice under section 79 and 80 of CPC was served, and therefore the suit itself was not maintainable. And it was also stated that the suit land was recorded as Garibulka Khas, and the same vested in the state after vesting of Sunny Valley. It was also asserted that the decree passed in title number 28 of 64 is collusive, and the plaintiffs had fraudulently managed certain entry registered to in collusion with the current trial. The following issues were framed by the learned court. The learned court recorded that the suit between the plaintiff and their vendor was dismissed on compromise, and also refers to the provision of law that transfer of immovable property more value more than rupees 100 can be done only by registered document, and the oral transfer cannot be recognized by court. The learned court also recorded that issuance of a receipt does not confer any title. The learned court also recorded that the exhibit A series and B, which showed that the suit land has been notified as protected forest, and the plaintiff gave and accept oral evidence showing the nature of land at Grand Medulla has failed to bring any concrete reliable documentary evidence. Framed the following points for determination. And after recording concurrent findings, has dismissed the appeal. This court finds that the materials based on record have been discussed, and the suit was dismissed on numerous grounds, including want of notice under section 80 of CPC. Evidently, the plaintiff did not produce the notice and issued under section 80, but only proved certain postal receipts. This court finds that the learned courts have duly appreciated the materials on record. No perversity in the matter of appreciation of evidence as such has been pointed out by the learned counsel for Jharkhand. No substantial question of law arises for consideration. Accordingly, this appeal is dismissed.
Only one thing. Because your Lordship, in one case, the Honorable Court had said that matters of public importance, if they are there, then only second opinion. Only on that question, otherwise I would not have said.
कुछ पब्लिक इम्पोर्टेंस का बात नहीं है, नोटिफिकेशन ये सब कोई केस होगा तो उसको जरूर डिसाइड करेंगे, लेकिन अभी तक मेरे पास नहीं आया।
अभी तक ये कंट्रोवर्शियल
आया कंट्रोवर्शियल है, लेकिन आएगा ही नहीं तो क्या डिसाइड करेंगे? इस केस में नहीं डिसाइड कर सकते।
ठीक,
क्योंकि टेक्निकल रीजन से जो केस अदरवाइज इज नॉट सस्टेनेबल, तो हम सब्सटैंशियल क्वेश्चन ऑफ लॉ बना के क्या करेंगे? राइट, जिसमें कुछ होगा, बाकी सब चीज रेगुलर सूट होगा, उसको देखेंगे।
From date for orders Act 12, first appeal 145 of 2010.
In this request, on the last issues, notice was issued on respondent number 8 and 9, and also on the legal aids of respondent number 5 logic. But inadvertently on the last date's order, it has come respondent number 1's legal aid. And also the requisites were filed beyond that time of notice. That is why notice could not be issued.
Place name. What is the error?
You
refer to the order.
Order 30th July 2025.
July.
June.
So let notice be issued to the legal years of respondent number 1. It should have been
Respondent number 5 years. I have been filed correctly years.
so testimony. It has to go to the reference. FA number 145 of 2010. The learned counsel for the appellant has submitted that in order dated 30th July 2025. The notices have been directed to be issued upon the legal heir/representative of respondent number 1, but the respondent number 5 had expired and respondent number 1 is alive.
Yes, ma'am.
She submits that the order requires modification. Office is directed to place this case before appellate bench for modification.
Item 13 second to 216 of 2018.
In the limitation matter, the notices were issued. And after that, now notices have been served. Now, office notice not with regard to the respondent number 3, 4, and 5. Allegedly reported to be dead. Now, those 3 respondents died not during the pendency of the appeal. This is a judgment of reversal. So, the present respondent number 1 and 2 were the appellant in the trial, in the appellate court below. And they did not take any step for substitution. They were pro forma respondents in the title appeal. Now, when it was reported, then the appellants made inquiry and then we filed IA number 7014 of 2002. That is for order 22 4 and 9, read with section 5. Explaining all these things subject to sustained period. Now, the problem is that it is a suit for declaration of right to interest and recovery of funds. So we have succeeded in the suit. Suit was dismissed. Then they preferred appeal. Appeal will not allow. So against the judgment of reversal, it was 18 days delay. So in limitation matter, notices were issued. Obviously, the last order then it could be served upon the survivor. Notices have already been served, but nobody is turning up. And in execution case, they are taking hurried steps, and the 5th of October is the date for execution, last date to bring stay order. Number of whatever may be the date of this.
I have proposed stay petition filed here.
Filing. That is earlier to this petition. That is IA number. That is also on board. That is IA number 2188.
डिले भी नहीं करना हुआ है ना
ना इसीलिए तो
आप वहाँ पे एग्जीक्यूटिव कोर्ट में नोटिस
वो जो
टू द एग्जीक्यूटिव कोर्ट
करेंगे, लेकिन तुम मर गए हो उसका तो पार्टी
वहाँ पे तो सब्स्टिट्यूट हो गया होंगे ना
वहाँ वो सब्स्टिट्यूशन अपील में ही नहीं किए. टाइटल अपील जो था तो 2 पार्टी तो
अपील में नहीं किए तो एग्जीक्यूट तो वही लोग करा रहे
इसलिए
हैं
जजमेंट अगेंस्ट डेड पर्सन हो गया. Appellate judgment is against dead person. It is a nullity in the eyes of.
Appellate judgment is a judgment in favor of dead person या against
नहीं, pro forma respondent.
परफॉर्मेंस
उसमें से 2 थे प्लेंटिफ, 1A 1B, एक थे डिफेंडेंट. तो एक तो इनके फेवर में, 2 के फेवर में, एक के खिलाफ.
खिलाफ क्या हुआ वो तो
pro forma थे. जो भी उसमें तो उनको नोटिस
आप नोटिस करिए नोटिस सर्व नहीं होगा तो बहुत
IA number 2188. Sorry, IA number last IA 7014 of 2025 for substitution of respondent number 3, 4, and 5, setting aside everything. There are one I have stated. One is 2% of the all were pro forma respondents number 3, 5, and 6 in the title. There are one I have stated. And in the body also I have stated, narrated each and
when
every.
did they die
Yes, sir, in 2010. That is what you will see, can see paragraph 9. Para 9. One person died in 2008. That is Juman Mia. Respond number 3. Here respond number 3. 2008. Leaving behind the legal heirs are giving the details. And para 10 relates to respond number 5. Muslim
what is
also.
the date of the impeachment judgment
Yes.
17
17. So during the pendency of the appeal they died. 2007 appeal was filed.
इसमें कोई भी नहीं अपील किया अभी तक।
सर्व हो गया नोटिस। जो contesting है वो है respondent number 1 and 2. They are in this appeal. They are contesting plaintiff, respondent number 1 and 2.
ये there are 3 IAs pending.
Yes,
One
one
is
is for
39.
condonation of delay,
Yes.
earlier one, and second one is not for stay of execution proceeding, and third one for substitution come setting aside everything.
Substitution setting aside section 5 दो बार section 5 हो गया, दोनों अलग अलग के लिए कि एक ही के लिए?
This section 5 to एक ही है 1839/2023.
देखिए ऐसे नंबर 216 of 2018 IA number 1839 of 23, IA number 2188 of 21, and IA number 7014 of 25. The learned counsel for the appellant has submitted that notice upon respondent number 1, 2 and 4 is validly served, but by order dated 7/8/23, the proceeding against respondent number, the appeal against respondent number 3, 5 and 6 is stated to have been abated. He submits that a petition for condonation of delay in filing the appeal has been filed, which is ID number 1839 of 23, and ID number 7014 of 25 has been filed for substitution of respondent number 3, 5 and 6 for condonation of delay and setting aside abatement. And so far as ID number 2188 of 21 is concerned, the same has been filed for stay of further proceeding of execution case number 7 of 2020. The learned counsel submits that the appellants were the respondents before the first appellate court, and the present respondent number 3, 5 and 6 were the pro forma respondents in the same case.
Yes.
He submits that as per the interlocutory application being IA number 7014 of 2025, Tuman Mia,
Yes.
who is pro forma
Respondent number 3.
pro forma respondent number 3, died in and around the year 2008. Muslim Ansari, pro forma respondent number 5, died on
V11.
11 to 2010, and Basir Mia, pro forma respondent number 6, died on 16/3/2008. He has submitted that all these 3 respondents had expired during the pendency of the first appeal, title appeal, and it was for the appellant who are respondent number 1, who are the respondents in the present case to take appropriate steps for substitution. But no such steps were taken, and ultimately a decree was passed wherein dead person were on record. The learned counsel submits that the contesting respondents are not appearing in this case in spite of service of notice, and the execution proceeding is going on at pace, and next date in the case,
Fifth
in the
of
execution cases 5th of
October 2020.
October 2025. He submits that if the aforesaid statement, in view of the aforesaid statement made in the interlocutory application being ID number 7014 of 2025, mentioning that the respondent number 3, 4 and 3, 5 and 6 had expired during the pendency of the first appeal, then the appellate judgment is a nullity in the eyes of law. The learned counsel submits that the proceeding in the execution case may be stayed so that the respondents may take appropriate steps in the present case.
Yes. Yes.
He submits that on the one hand, they are not appearing in the present case and steps are being taken for the execution.
Yes.
Considering the aforesaid submissions, let notice be issued to the proposed legal heirs and successors of respondent number 3, 5 and 6, whose details have been given in the interlocutory in paragraph 9, 10 and 11 of the interlocutory application. Under speed post, for which requisites be filed within a period of 1 business days. आइए मैं करेंगे, ठीक है? In view of the submissions, let the further proceedings in execution case number 7 of 2020 pending in the Court of Civil Judge within that Jubilee Division -2 Dhanbad or the successor court
Yes.
is stayed till the next date.
Yes.
Post this case on 4th of November 25 till 4th of November 25. Let this order be communicated.
Yeah.